All right, in the interest of time, I will go ahead and get started. I'd like to introduce myself first. I'm Kendra Billow, and I'm with AGC of California. I wanted to welcome you to Leveraging Data to Mitigate Claim Risks, sponsored by Abouthamatech, featuring Pierre Ryan. The session today will last approximately 1 hour, and we will include time for questions and answers at the end of the session. Please feel free to utilize the chat or Q&A features on the menu bar at the bottom of your meeting window at any time during the session in order to ask questions. We'll be monitoring the questions that come in, and we'll address those in the Q&A section at the end. If time doesn't allow and for some reason we don't address all of the questions during the presentation, or maybe you think of something after the session has ended, I'm going to be dropping my email address in the chat box. There you go. And don't hesitate to reach out to me following the WebEd today. If you do have additional questions, I can facilitate communication between Mr. Ryan, Abouthamatech, or wherever the questions should be directed. With that, I'd like to take a moment to introduce Pierre Ryan. He is an attorney based in Southern California with the construction specialty firm Hunt Ortman. He studied international business at the University of Southern California and continued his education at Notre Dame Law School, graduating cum laude. Mr. Ryan specializes in construction-related litigation and transactional work. As national counsel for entities operating in multiple states, Mr. Ryan assists in the coordination and execution of legal strategies throughout the country. He believes in the modern practice of law and strives to deliver maximum value to his clients by leveraging the project management and documentation platforms being rapidly adopted throughout the construction industry. And with that, I'd like to turn it over to George Burgers of Abouthamatech and Pierre Ryan to begin the presentation. Georgia?
Thank you very much, Kendra. And thank you everyone for joining us today. So I'm Georgia Burgess. I'm the Partnerships and Field Marketing Lead at Abouthamatech. For those of you who don't know us, Abouthamatech was founded in 2013 and is a cloud-based software platform for field operations, ensuring safety, quality, and operational efficiency. So we were built around people and field processes. We believe that there are 3 things essential to field operations. The worker is at the heart of the construction process. That's the first piece for us. The second is that systems must follow processes and not documents. And with these 2, it provides you with action-based and actionable business insights. So how we do this is by keeping the workers at the heart of our software platform too. And we do this by wrapping the workflows around their unique Abouthamatech profiles. When you do this, you gain a 360-degree view of reportable data that's based on all workers' activity. So we're an all-in-one platform from pre-start to closeout, and we're configurable to your unique processes, starting with virtual orientations and covering the full spectrum of field processes, giving you extensive and reliable business insights. Quality data is inseparable to claims mitigation and claims management. And with that, today we're happy to present a collaboration with Pierre Ryan at Hunt Ortman. And with that, Peter, I'm going to turn it over to you. Thank you.
Thank you, Georgia. Good morning, everyone. As Georgia just mentioned, my name is Pierre Ryan, and I'm a construction attorney based in Pasadena, California at the law firm Hunt Ortman. The purpose of today's webinar is to offer my observations from working with construction industry clients regarding the challenges and opportunities posed by the rapid adaptation of construction technology to projects. Based on these observations, I will also propose some approaches to manage risk and maximize the opportunities created by construction technology. Let's get started. In order to ensure that digital tools mitigate rather than amplify project risks, we need to identify the preliminary triggers what the preliminary triggers of these risks are. Well, there are many, and they vary by contractor and by project. In assisting clients, I've identified 4 common pain points. The first area is the inconsistent use and coordination of digital tools. The mix of technology employed by various parties on a construction project often defines whether or not that technology improves overall efficiency or otherwise. The second area we're going to touch on is resistance or inability by leaders in the field to capitalize on new technology. Hesitancy to apply technology or failure to use it to its full potential can severely limit even the most powerful tools. Third, we have failure to properly manage construction technology data to reduce and resolve claims. A ton of information is being generated by construction technology tools on projects today, but gaps in users' ability to digest that material is resulting in missed opportunities to mitigate risk and resolve claims. The final pain point, and the one that's nearest and dearest to my heart, inadequate coordination with counsel, producing unnecessary legal expenses. While the vast amount of data generated by construction technology can prove a powerful tool for counsel, ill-prepared data and/or counsel and experts without an appreciation for the project information being generated can cause legal costs to balloon and opportunities to be compromised. Problems such as the ones I've identified above are easy to identify, but we're here to talk about solutions. Today, we're going to discuss 4 areas of focus to reduce the risk that I've just outlined and maximize the potential of construction technology from a legal standpoint. We'll begin at the beginning of the project with a prime contract and corresponding subcontracts. How can we use these agreements to manage expectations and ensure cohesion with respect to construction technology on projects? The second area concerns attitudes and adaptation to new technology. Are you applying construction technology where it counts? And are your leaders positioned to effectively leverage this technology? The third area of focus is management of the massive amount of digital records being generated by construction technology. Are you positioned to digest this data in a way that will permit you to evaluate risk? And can you identify and act on negative trends before they become larger issues? Finally, we will discuss litigation preparation. Is your construction technology data being delivered to counsel in a digestible format? And is your counsel well positioned to use that information to advance your legal rights? The contract is a tool for digital consistency. Setting expectations for the capability and application of construction technology in contracts is increasingly an important way to minimize disputes on projects. What's the biggest issue we're seeing? The biggest issue we are seeing pop up with respect to construction technology requirements in contracts is inconsistency between explicit technology requirements in prime contracts and corresponding subcontracts that do not contain these requirements. While it's true that many subcontracts incorporate the prime contract by reference, this does very little to set expectations for subcontractors who may only pay attention to their individual subcontract. It is worth noting that many owners are still relying on AIA contract forms, which do not currently include any specific technology requirements. But it's also worth noting that many more savvy developers are beginning to include addendums to write these requirements in. My advice to GCs is to look for explicit technology requirements in the prime contract and ensure that subcontracts mirror those requirements to the extent required. But what about subcontracts? While legal disputes between the GC and the owner do arise, even more common are disputes between the GC and its subcontractors. The most common legal disputes involving subcontractors that we deal with arise from poor change management and poor claim procedures. Your subcontract should proactively address these issues. They can do so by dictating clear change management and claim procedures and specifically tailoring these procedures to the technology to be utilized on the job in question. All right, we're ready for the first hot tip of the day here. First tip we have is when updating subcontracts, don't make contractual provisions concerning construction technology too specific. What does that mean? With the exception with any platforms that must be uniform among all parties, you want to identify what you want the technology to do in the context of the project, not the specific platform to be used. Technology is readily evolving, and overly specific requirements can both hinder projects and result in the need to constantly update your agreements. What are we seeing on the ground? I've recently been involved in assisting contractors with disputes in two similarly sized commercial projects. While both had some closeout issues between the GC and the owner, one project had 3 times the amount of claims involving subcontractors and material suppliers than the other. While every project is unique, it is noteworthy that the project with considerably less claims involving subcontractors and material suppliers had utilized a contractually mandated payment and change management platform, whereas the other left the subcontractors to submit their own change order documentation, which then had to be packaged and submitted to the owner. As demonstrated by this small example, more rigid procedures coupled with construction technology have the real possibility to reduce claims. Resistance to new technology and obstacles to adaptation, how do we tackle those? As with any change in the way things are done, addressing attitudes toward new technology and convincing the most seasoned professionals to play ball presents one of the greatest challenges. Traditionally, large projects meant more personnel. From project superintendents downward, GCs were limited in the size of the project they could take on by bonding capacity and their sheer ability to staff projects. But today, especially at the upper project management levels, we're seeing 2 distinct approaches to projects. Many GCs are using better project management software to allow less personnel to manage more aspects of the project, while others are sticking to older models, or notwithstanding the use of new technology, have not seen a reduction in the personnel required. This is mostly because the experienced people in the field are unable to use the new technology effectively and efficiently. Over time, this is shifting the competitive playing field and lowering barriers to entry to compete in larger projects. Investing in new technology is a relatively straightforward decision, but how do you ensure that your best people are able to effectively use this tech? The most compelling approach that I have seen is mentorship programs. These programs pair tech-savvy engineers just entering the field with seasoned leaders. This results in a reciprocal benefit of passing down essential skills from the most experienced people, while also giving those leaders the assistance of the tech-savvy younger generation and learning to effectively leverage new construction technologies. In summary, it's true builders' minds being shared and their abilities enhanced by the next generation who've been using screens and computers throughout their entire lives in education. It's a perfect match. Perhaps not as inspiring of a topic as mentorship, but we need to talk a little bit about data. Given the massive amount of data being generated by construction technology, a unique challenge is ensuring proper management and access to that data that is being generated in order to timely evaluate the information and act accordingly. Any construction technology health check should include the following 4 questions. How can you quickly access and evaluate the data coming out of your projects? 2, is pertinent information flowing to the right people in a timely manner? 3, do you have the ability to observe and act on trends before they become problems? And 4, can you quickly single out a claim and evaluate your exposure without digging through all of the data? These abilities are key to managing risk and evaluating any probable loss should a claim arise. By understanding these risks, many disputes can be rationally resolved. And if you pick a battle, you can ensure that you make a well-informed decision to do so. Lessons from the FIU Bridge Collapse. Back in 2018, mid-construction, a prefab bridge being constructed at Florida International University collapsed, killing 6 people. In addition to the lives lost, this horrible accident has had far-reaching consequences, including most recently the engineer of record's 10-year suspension from federally funded projects. Many lessons can and should be learned from this tragic accident, two of which shed light on the importance of proper management and dissemination of construction data. A 19-month NTSB review found design flaws, but also a failure by the builder, the builder's engineer, Florida International University, as well as the Department of Transportation to recognize the severity of cracking in the bridge and to close the street to traffic below days before the incident. Although ill understood, these issues with the bridge were documented extensively in the days before the accident. But most likely the information regarding the severity and risk of what was going on did not reach decision makers in time to prevent this accident. More efficient data compilation reporting might have been what was needed to spur action necessary to prevent this tragedy. But another lesson is apparent in the aftermath of the accident. The NTSB eventually found several parties at fault, but the investigation did not conclude for 19 months. Long before the conclusion of this investigation, the builder filed for bankruptcy under the weight of the claims. This may have been inevitable, but also may have been avoidable or done in a more legally advantageous way had the builder been able to quickly digest project data in order to evaluate risk of ultimate exposure and act accordingly. Well-managed project data is essential to act quickly to mitigate exposure and, if possible, preserve bonding capacity. For anyone not glued in their seat at this point, time to pay a little closer attention. I'm going to tell you how to save money on the real drivers of costs during disputes, the lawyers. Our final area of focus today is dispute resolution, namely arbitration and litigation. While construction technology data can go a long way in proving the merits of claims, there's also a significant danger of outsized legal costs generated by attorneys sifting through this massive amount of data. The legal industry has been slower to adapt to new technology than the construction industry, meaning that law firms are ill-equipped, or many law firms are ill-equipped to process construction technology data efficiently. And experts, many of them retired construction professionals, tend to be even less adept at processing and leveraging construction technology than the attorneys themselves. What is driving up costs in modern construction disputes? I've identified three key culprits. First, difficulty getting clients to deliver the relevant data in the most easily digestible and organized way. Second, even further difficulty obtaining relevant and organized data from the opposing parties and having obtained that data, organizing it. And third, difficulty efficiently reviewing the data for legal issues and putting it into a presentable form for mediation, arbitration, or trial. But how do we achieve optimum efficiency in litigation in this context? First, use attorneys that have a basic understanding of the construction technology used on the project in question. If they're not asking about the tech utilized, that's a red flag. This will be important in evaluating your own data as well as in tailoring discovery to other parties in an efficient manner. Second, use experts that understand the technology used on the project and can effectively incorporate all of the relevant data into their analysis. If the expert is not familiar, they need to be willing to spend the time to get up to speed with all of the pertinent technology and fast. Third, and perhaps most importantly, when harvesting data for litigation, be sure to consult with the software developers for the platforms you are preparing to harvest information from. And talk to your attorneys about using specialty discovery vendors to prepare the data for review and analysis, especially on large projects. In summary, it's your overall construction technology infrastructure that will make the difference in costs when forced to litigate or arbitrate disputes. Competent infrastructure, an organized way to deliver this information to counsel and experts, and attorneys and experts primed to digest this information efficiently will significantly reduce costs in resolving your disputes. Okay, a quick recap of the key takeaways from today before we take some time for some comments and questions. First, modernize your contracts with digital provisions. In light of the rapidly expanding technological capabilities on projects, attention should be paid to setting expectations from a contractual standpoint and incorporating technological requirements for efficient change and claim management into your agreements. Second, mentoring supports digital uptake in addition to knowledge transfer. Staying competitive in the world of rapidly evolving construction tech depends not only on investing in technology, but in ensuring that your most experienced people can effectively leverage these tools. Mentorship programs have the reciprocal benefit of giving true builders access to the technologically savvy younger generation entering the field while passing along the true builders' vital knowledge. Third, project data is most useful when you can access and digest it quickly. Used and managed properly, construction technology data reduces exposure and allows users to identify, evaluate, and mitigate risk before large issues arise. And finally, quality data provided to tech-savvy counsel will reduce your litigation exposure. To ensure that construction technology helps reduce dispute resolution costs, it is important to seek assistance from platform developers and for large projects to utilize vendors to deliver project data to your counsel. It is also imperative to ensure that both your counsel and any experts you're using understand the technology and information available based on the construction tech used on the project. Thank you guys for listening today, and now we'll have some Q&A.
Thank you very much, Peter. That was wonderful. We do have a couple of questions that have come through. So I'll just start with the one that came through in first order. So this listener is wondering, have you seen examples of new standard contracts that are covering tech provisions that they should look to model or to research?
So probably the most popular form contract that's used for projects today is AIA, and they have not updated. I'm not currently aware of any other of the form contracts that explicitly do so. My recommendation would be that you work with counsel to form your own contracts tailored to your needs that add these features, and to the extent you have the negotiating power when negotiating contracts with owners, that you add in addendums to address these provisions.
Fantastic, thank you. And the next one is, how much more exposed are you when you have manual processes or even a combination of manual and digital?
So I guess that really is a question of degree, but I can answer it this way. The gaps in basically what construction technology allows you to do is to fill in gaps in information that you would otherwise have in the context of a dispute. If you're just talking about a completely non-digitalized dispute resolution process, the process is going to be digging through the paperwork for the project, conducting depositions of all the personnel on the project to figure out the story of what really occurred. But what the data from construction technology is really allowing us to do, it's allowing us to fill in a lot of those knowledge gaps and get the story straight much quicker. So from an exposure standpoint, what that's going to do is it's going to pick winners and losers quicker. It's going to leave less ambiguity, and it's going to ensure that disputes are hopefully resolved more quickly during either pre-dispute discussions or mediation, rather than going all the way through arbitration or litigation when things really get unnecessarily expensive. Brilliant.
And we've got one around win-loss. So how is this going to affect an organization's ability to win or lose a case in the instance of dispute?
So going back kind of to my answer to the last question, really it's, I mean, not to be cliche, but it's not whether you win or lose, it's how you play the game. That's how it is in arbitration, mediation, or litigation. And what I mean by that is, yes, I mean, there is negotiation, but ultimately the facts are the facts. And really, everybody loses if a case goes all the way through arbitration or litigation because of the vast amount of money and time resources that they're spending. Even if they get attorney's fees back, they're never going to be able to get the time their personnel and themselves had to spend participating in this case back. So basically, the way that, although it's difficult to say whether or not it really would change who wins or loses, it's going to make it more likely that a claim is resolved before you have to have a definite winner or loser, and everybody wins in that context.
Fantastic. I don't see any other questions that have come through. Oh, actually, wait a minute. There we go. I just saw one that said, so how many of these suits do you see in a year?
How many of just general suits, or generally what happens, I guess full-scale lawsuits really only end up happening, we probably handle maybe 20 a year, something like that. Whereas, but disputes, we're constantly dealing with helping our clients navigate, I guess, pre-disputes on projects. So, that would be a much more significant number, but it is true that increasingly so, disputes are being resolved before you really get into arbitration or litigation. Mediation is more common, but even just informal negotiations is the way that we're resolving a lot of claims today.
We've got one from a gentleman called Michael Goldstein. So this is around insurance, Peter. So you talk a lot around the importance of the council understanding technology and being able to digest project data. But what about the insurers, insurance providers' ability to do the same? Should that be a consideration when selecting an insurance provider?
I would say certainly, and the reason is that insurance providers that are able to basically weigh this data, and increasingly this is happening, they're able to lower your premiums based on analysis of what's happening on jobs. And if they're, I guess it's a double-edged sword, because if you end up having a job that's a mess, your insurance carrier, if they have access to the data, is going to be aware of that ahead of time, and that could affect your premiums. But if you are confident in the way that your ability to carry out projects, yes, if you can find a carrier that one is has an option to allow them to track certain data as a condition to having lower premiums, that's certainly desirable. And also in the context of an actual claim that might occur, being able to explain the situation to the adjuster, and whether or not it's somebody who's making a claim against you or whether or not you're making a claim, to being able to explain that and support it with data so they know they're on your side, and is very helpful.
Thank you, Peter. So I don't see any further questions that have come through, and so with that, if you do have further questions that arise following over the next coming days or weeks, please do drop Kendra a line, or there's Peter Ryan's email up on the screen in front of you. And so with that, I'll say thank you very much to everyone for joining. I hope you found that really informative, and we look forward to keeping in touch, and enjoy the rest of your day. Kendra, I'll hand it over to you.
Thank you very much. That was awesome. Thanks, Peter. Thanks, Hammertech, for supporting this. I will be sending out a recording of this WebEd following the session today, so please be on the lookout for that. And as Georgia mentioned, if you have any additional questions, you could feel free to reach out to any of the three of us, and we'll make sure that we address those for you. And we look forward to seeing you again in an upcoming WebEd. Thanks for your time today, everyone.
Thanks, everyone.